Hello and welcome to our 2021-2022 workshop on Ohio's Sunshine Laws. I recently presented this workshop for all schools sponsored by the Ohio Department of Education, and we appreciate having the opportunity to review the information with you as well. Links to the Ohio Revised Code sections 121.22 and 149.43 are provided for your reference. My name is Yvonne Adkins, and I'm the Chief Consultant for Adkins & Company, LLC. We have created this workshop to help charter school governing board members increase your competence and your confidence in understanding these statutory requirements and to meet the annual requirement for both open meetings and public records training. Many of you have taken various trainings on these topics in the past, and because it's an annual training requirement for charter school boards, we've created a brief presentation so that all of your board members can view it and maintain compliance with the open meetings and public records training requirements. Our goal of the workshop today is to provide you with training on how your board, as a public entity governing an Ohio community school, can maintain compliance and conduct business according to the Sunshine Laws. In addition to viewing this video, we're also providing additional resources for all attendees as well. Please take the time to review the Roberts Rules information, public notice and policy sample information, and the statutory references. So, what is a public body? A public body is any board, commission, committee, council, or similar decision-making body of a state agency, institution, or authority, and any legislative authority or board, commission, committee, council, agency, authority, or similar decision-making body of any county, township, municipal corporation, school district, or other political subdivision or local public institution. Ohio charter school boards are considered public bodies because the board is performing a public function in governing your public charter school. Ohio law requires that all public bodies or public offices conduct business in open meetings. So, what is considered a meeting? A meeting means any prearranged discussion of the public business of the public body by a majority of its members conducting or discussing public business of the public body or the school. This can relate to committee meetings, work sessions, and retreats. The Open Meetings Act prohibits any prearranged private business-related discussion of a public body regardless of how the discussion may take place. This could be in person, via email, or through a Zoom or Teams meeting, or even a telephone conference. Every public body shall establish a reasonable method whereby the body will notice their various types of meetings. Regular meetings, special meetings, and emergency meeting notices and processes for complying with requirements should be adopted by the board and reviewed annually for compliance. Regular meetings should be posted well in advance. Your board probably adopts a board meeting calendar at the beginning of the year, and you can post that on your website. Special meetings and emergency meeting notices are different, and the board must follow a board-adopted policy to address such. Note that the board may have the need to schedule a special meeting to adopt a policy, or something that can't wait until the next regularly scheduled meeting. Perhaps there's a need for an emergency meeting for something like a water main break or an issue that needs immediate attention. For these situations, the board can only address the topics on those meeting notices. So you'll want to ensure that you follow your policies and notice the meetings appropriately so you can address required items and maintain compliance with sunshine laws. The different meeting notice procedures should be identified in a board-approved policy or in the board's bylaws. Make sure your staff is informed of board adopted policies in, in that they know how to follow such for all of these various meeting requirements. Ohio's charter schools had an exception last year due to the coronavirus. As you know, Governor Mike DeWine's emergency declaration, House Bill 197 or HB 197, allowed public bodies to meet using technology during the coronavirus state of emergency. This emergency declaration ended on June 30th, 2021. School boards had to go back to ensuring that a quorum was physically present at the building or the location of meetings going forward. Members of the boards could still participate using remote connections if you couldn't make it in person. However, you could not be counted towards a quorum, and the vote could not count if the board member was attending remotely. Many boards are still allowing a Zoom, telephone, or Teams meeting connection for service providers and additional guests to attend their meetings. This has allowed public participation to occur more often, and we believe that this is a positive. We're now seeing notices of board meetings including a physical location and still including a Zoom or telephone call-in information. So there's an option for remote attendance, even if it is just to listen in and not be counted towards the quorum. We think that this is great and can encourage parent and additional stakeholder interest, but please just remember that you must have a quorum of the board present at the meeting. Again, board members cannot vote and cannot be counted towards the quorum if you are attending via a remote connection. This is the way it is right now. We have not heard that they're going to allow remote connection counting towards a quorum anytime soon, but if that does change at all, we will make sure that we let board members know. There are some exceptions to all business being conducted in public session. No public meeting notices must be posted for things like audit conferences, collective bargaining meetings, special events that don't constitute a meeting if board business is not being conducted by the membership. Executive sessions can be used for deliberations of permitted topics only. No action can be taken in executive session, and the notice and agenda should include executive session if the board plans on going into a closed session. This is a really good practice to include the potential executive session on the notice, just in case. Executive sessions may be used for specific allowable purposes only. Allowable purposes could be a specific personnel issue, real estate negotiations, security purposes, or other confidential matters as prescribed by law, legal action pending or imminent litigation, and if that is the purpose for the executive session, you have to have your attorney present to participate in that executive session, and collective bargaining agreements as referenced earlier. You'll want to ensure that you're using Robert's Rules of Order to conduct your meetings. Executive sessions can be entered into by someone making a motion, another member seconding the motion, and then taking a roll call vote of all board members present at the meeting. No voting or decision making is allowed in executive session. Minutes are not taken in executive session, but the minutes of the meeting must include information from the rest of the meeting and must identify the purpose for the executive session as well as the time in and out of the session. Public is removed from an executive session. However, the public body may invite attendees into the closed session, including like the sponsor oftentimes attends executive sessions, board counsel, or if there are specific experts or individuals that the board will want to consult for that purpose of executive session. Violations of open meetings requirements can be very serious. If a violation occurs, any action taken at the meeting in question may be void. A violation may be brought to the Court of Common Pleas within 2 years. Courts may issue an injunction compelling members of the public body to comply, and if an injunction is issued, the court is required to a penalty of $500 against the public body and may require payment of court costs and reasonable attorney's fees if the party bringing the suit. So open meetings requirements are important to be followed for all public bodies, including public charter school boards. Public bodies like charter school governing boards must retain all public records. These are records of the meetings, actions, and proceedings. So what is a public record? A record or a document, device, or item, regardless of its physical form, that is related to action or deliberation of action of the public body. The record must be created or received by the public body, even if they're not in possession of the document. The record documents the organization's function, policies, decisions, procedures, or activities of the office. It's the decision or content of the record that is the record, not the medium on which the record exists. We've had questions as to why we need to collect board book materials, or why, as a sponsor collects minutes or financials as well as board book materials. And this is a perfect place to mention that anything proposed in a public meeting is then public record. So agenda items and support materials presented at that public meeting are public record, and you'll want to ensure that you maintain copies of those things and make such available to your sponsor if requested. Public offices must retain all public records, but not everything qualifies as a public record. So what is not a public record? A public record must already be in existence. So someone could not make a public records request that would require you as a public body to create a new document. A public record of the board would have to be something that the board does, something that you did or acted upon, or something that you used in your operations. Just because the board received a communication, if the board didn't actually use it or didn't act upon it, then it would not fall under the definition of a public record of your public body. You should always reach out to your counsel before responding to any public records requests. The board should work with your counsel to ensure you have a public records policy and a public records retention policy with a retention schedule, so that you have a board-approved written policy to follow. The board and the school needs to know how the records are to be handled for the school, as well as who will retain the records and who will respond to records requests once received. It's the board's responsibility to ensure that the school is following the board-adopted policy and schedule. So these policies should be reviewed annually, especially if there are leadership or administrative staff changes. We hear many questions about public records outside of public board meeting materials. We know that board materials are public record, but also emails, notes, and draft agreements may all be considered public records, depending on the content and the issue. What is a proper public records request? Requests cannot be overly broad, and while the requester does not have to identify themselves or the reason of the request, the public body can work with the requester to ensure the response will meet the requirements if they know who and why or the purpose of the request. It's always good to try to find out what the purpose is so that you can try to meet the requirements. Are the documents requested relevant to what the school does, and does the school have a board-adopted policy that you will follow to respond to the request? There are exceptions to access to public records. Some documents cannot be disclosed. A public body cannot give out health records. The public body cannot give probation or parole proceeding information. You cannot provide adoption or child support or trade secret information. No personal information of students under the age of 18 can be provided unless the school has prior written consent from the parent or the guardian. We always recommend working with your counsel prior to responding to any public records request. Again, work with your attorney to ensure the request is relevant, that it's not overly broad, and work with the requester on a timeline and a method for distribution. Prepare to redact information that is necessary or request more detail to ensure that the request is limited to what is really being asked for by the requester. There are various other training options for Sunshine Law compliance as referenced on this slide. Your sponsor also offers open meetings and public records training. We know you're very busy, so we wanted to highlight key points for you in this training. However, the links on this page will take you to additional information, including the Ohio Attorney General training and the Sunshine Law Manual that can be very helpful as for references. So let's overview. We know that governing board meetings are critical to your school's success. This is the time that you conduct business. Make sure you notice your meetings in compliance with your policies. Follow proper public meeting protocol, like Robert's Rules of Order, and don't have outside conversations or meet with board members about the school outside of board meetings. Ensure all items are on your agendas and all board materials are maintained in an organized fashion. Always check with your legal counsel to ensure records requests are addressed properly. Thank you for your participation today. I know many of you have enjoyed our open meetings and public records training before, but some of you may be new to it. We welcome any questions that you may have, so feel free to reach out to me to discuss. I know that there are other folks out there that get excited about public records and open meetings, so if you just want to talk through something with me, please reach out anytime. You can reach me at yvonne@adkinsandcompany.com. Again, please feel free to reach out anytime, and thank you for participating. Have a great day.